I'm Jim McAdams. I'm the director of the Nanovic Institute for European Studies, and I want to welcome you to the second day of our inaugural Nanovic Forum. I want to tell you a little bit about the forum first, and then say something about our speaker and respondents. The Nanovic Forum is the brainchild of our founders, Robert and Elizabeth Nanovic. Their idea was to bring some of the most distinguished European thinkers to Notre Dame, writers, historians, politicians, musicians, lawyers, and give them the opportunity to engage students and faculty on whatever issues interested them the most. These forums might include a myriad of different forums, including public lectures, film showings, meetings with students, seminars, or readings from their latest book. Last night, our guest gave a terrific introduction to a film that was made from one of his novels, The Reader, if any of you have read the book or seen the film. Tomorrow, he will offer a public reading from his latest novel, The Weekend, which is based upon a wonderful idea. It's about a weekend gathering of old friends, kind of like the Big Chill, if any of you know that. One of the friends of whom happens to be a former terrorist and who has just been let out of prison. So it gives cause for some meditation. This reading will take place at noon in the Amos Student Lounge at the Coleman Morris Center. This afternoon, of course, our guest will speak about the law. And we are fortunate to have two of our good friends and esteemed colleagues to act as respondents, Rick Garnett and Don Kommers. And now I'll say something about our guest. Bernhard Schlink is an extraordinary individual who has that unique ability to think and act in multiple fields and to address big questions, big concerns about humanity. I should say not just unique, but enviable. Aside from being a very successful novelist and essayist, Professor Schlink has pursued a distinguished career in the law. He studied jurisprudence at the Karl Ruprecht University in Heidelberg and then at the Freie Universität, the Free University in Berlin. He wrote his first dissertation on a concept I love because it's beyond me to translate, but Abwägung, which delightfully means everything from trade-off to balance to, yeah, balancing is good, on the concept of Abwägung in constitutional law. He then defended his second dissertation, his Habilitationsschrift, in Freiburg on the topic of legal cooperation and the division of powers among administrative authorities. For nearly 2 decades in his distinguished career, Professor Schlink sat as a judge on the Verfassungsgericht, the Constitutional Court of the state of North Rhine-Westphalia. Most recently, he was a professor of law and the former dean at Humboldt University in Berlin. I'm really delighted to welcome Professor Schlink to our law school and to Notre Dame, where he is now going to lecture on the topic of proportionality in constitutional law, why everywhere but here. Professor Schlink.
Well, thank you very much for this nice welcome. Suppose you are a judge, not on a European constitutional court where the principle of proportionality is generally accepted, nor on the US Supreme Court, where, at least according to general wisdom, the principle is hardly known and hardly used, but on a fictitious moral court. No statutes, no precedent, each case is decided on its moral merits only. Two neighbors, John and Frank, who live high up in the mountains, come before you. In the middle of a cold and stormy winter night, John took Frank's four-wheel drive car without asking and didn't return it until the next evening. Frank, who had wanted to pick up his old mother in the morning at the lonely bus station in the valley, couldn't do so. The old lady stood in the cold for 2 hours before the postman drove by, who brought her to the hospital with frostbite. Frank thinks John should at least apologize for his immoral action. John is truly sorry for what happened, but thinks he shouldn't be morally blamed. You are the judge. What will you do? You ask John how he could do what he did. He explains that he took Frank's car to bring his pregnant wife to the hospital. Her water had broken. You ask why he didn't use his own car. He explains that he needed a four-wheel drive car because it had snowed heavily. You ask why he took the car without asking. He points out that he and Frank had often taken and used each other's things without asking, and that he hadn't wanted to wake Frank up. Then you turn to Frank. In view of what John has explained, does he still insist on an apology? Frank does insist, because he had told John of his plan to pick up his mother the next morning. You confront John with this information. He says he is sorry for the old lady's frostbite, but that he knew that with the postman driving by, nothing serious could happen to her, while his wife's situation was a matter of life and death. You call the hospital, and it turns out that indeed John's wife, who delivered unexpectedly early, could have died if she hadn't reached the hospital when she did. And it also turns out that Frank's mother has recovered well and fast. Whatever you decide, maybe that John and Frank should reconcile because what happened was a chain of unfortunate events, you have engaged in a proportionality analysis. You asked Frank about the end that he pursued. You found out that the end was legitimate, that his action was a helpful, even a necessary means to pursue the end, that there was no alternative means that would have harmed John and his mother less, and that the end, saving John's wife's life, was important enough to justify the harm done to Frank's mother. Proportionality analysis is about means and ends. And whenever there's no law, here no moral law, specifically commanding, prohibiting, or allowing an action, we justify or condemn the action based on the legitimacy of the end pursued and of the helpfulness, necessity, and appropriateness of the action as a means for the end. The corresponding proportionality principle reads as follows. If you pursue an end, use a means that is helpful, necessary, and appropriate. A means that doesn't help to reach the end isn't really a means. To use it would be out of proportion. It is also out of proportion to use a means that is more than necessary, for example, more harmful or more expensive. It is equally out of proportion to use a means that is inappropriate because, even though it is necessary, by using it, you do more harm than the end is worth, or you spend more than you gain. It would have been out of proportion and in our context immoral if John had, let's say, taken Frank's helicopter that, even though he knew how to start, didn't have the skill to land. It would have been out of proportion and immoral for John to take Frank's four-wheel drive car if John's normal car would have worked just as well. And to do so would have been out of proportion and immoral if not the life of John's wife, but the life of Frank's mother would have been in serious danger. In short, enough is enough. Too much is out of proportion. More than enough is out of proportion, more than necessary is out of proportion, more than appropriate is out of proportion. So don't do more. In law, the principle of proportionality assumes prominence in those cases where, again, specific norms commanding or prohibiting specific means, or to be more precise, actions that serve people as means, are lacking. The right of self-defense is one example. Everyone is entitled to defend his or her life, liberty, and property. To pursue this end, he or she is entitled to use means that would otherwise be prohibited and may thus cheat and strike and shoot. No action that might become helpful and necessary for one's self-defense is prohibited categorically. But the law doesn't go so far as to allow one to act any way one wants. Unable to deal with the abundance of self-defense situations more specifically, it requires proportionate self-defense. Let's assume, it's a classic German law school hypothetical, let's assume there is a lame man who sits on his porch and sees a child climbing into his apple tree and picking apple after apple. He shouts, but the child just laughs. His only means to drive the child off the apple tree is to use a gun that happens to stand there and that he can reach, and to shoot the child down. The means of shooting the child is helpful and is even necessary to reach the end of defending his property. But we easily agree that it is inappropriate or imbalanced. The life of the child is much more precious than the value of a couple of apples. Here, the balancing of the property to be saved with the life to be sacrificed appears as the last step of proportionality analysis. That is often the case. The Federal Constitutional Court of Germany, for example, had to review whether the state could extract a defendant's cerebrospinal fluid in order to determine his mental capacity. It decided that determining mental capacity was a legitimate goal and that the extraction was helpful and necessary. However, the court recognized that since the extraction is painful and dangerous, the state can require an extraction to resolve only a serious crime. Only then are the pain and danger of the extraction and the resolution of the crime well balanced. But sometimes balancing also appears as the framework for proportionality analysis. The United States Supreme Court, for example, to review the use of deadly force against fleeing felons, balanced the state's interest in preventing the escape of a criminal with the individual's interest in preserving his or her life. To find the proper balance, the court engaged in a means-end analysis that had characteristics of proportionality analysis, even though the court didn't name it that. The court focused on the use of force against fleeing felons as a means and on the means end. The end is to protect citizens. Therefore, deadly force is necessary against a fleeing felon only if he or she poses a serious physical threat. Only in these situations does the court regard the use of deadly force to be well balanced. Be it in jurisprudence or in legal literature, we find both balancing as the last step of proportionality analysis and balancing as the framework for proportionality analysis. This can be confusing. But it only means that, as happens often, one and the same problem can be tackled from different angles. In Germany, the principle of proportionality came into its own not in criminal law enforcement, but in administrative law, when the police act to protect the public. From the late 18th to the early 20th century, the relevant norm provided little more than a definition of the task of the police. The police had to do what was necessary to fight dangers to public safety and order. The norm was understood to give the police wide discretion in fighting dangerous behavior of all sorts, from offending the Prussian king at a socialist rally, to building a house without proper structural engineering, or running a chemical plant without proper waste disposal. In the beginning, the norm even was understood to give the police uncontrolled discretion. But once the ideas of individual rights and the Rechtsstaat, the state under the rule of law, began to prevail, the courts started to institute controls over the police. The days of uncontrolled discretion were over. In the last decades of the 19th century, the Prussian High Administrative Court developed this norm, a norm that did not more than define the task of the police into a jurisprudence of proportionality. The police were entitled to use only means that were fit, necessary, and appropriate, or as it was also called, proportional in the narrow sense as opposed to proportional in the wide sense, including fit, necessary, and appropriate. The means had to work. There was to be no other means that would be equally effective but less intrusive, and the end was to be important enough to justify the intrusion. The court had two and only two premises. First, the police were entitled to do what was necessary to fight dangers to public safety and order. Second, citizens' life, liberty, and property were protected against police intrusion. Together, the two premises created a dilemma. It is impossible to fight dangers without intruding into citizens' life, liberty, and property. So how could the police fight dangers and intrude, and at the same time protect citizens against intrusion? The court resolved the dilemma by allowing the police to intrude, but not in an arbitrary way, and by defining the non-arbitrary way as the proportional way. In the second half of the 20th century, the German Federal Constitutional Court found itself with two very similar premises and not much more. The German Constitution contains a Bill of Rights that grants individuals a wide variety of rights and freedoms. At the same time, the Constitution empowers the legislature to limit these rights and freedoms and to intrude upon them. Here again is the dilemma of how to reconcile these provisions. The Constitution's grant of rights cannot mean that the rights trump the legislature's power. Nor can the Constitution's empowering the legislature mean that the citizens' rights are meaningless. The provisions have to coexist, and again, together they can mean only that the legislature is empowered to limit and intrude, but not in an arbitrary way. And again, the court defined and still defines the non-arbitrary way as the way under the principle of proportionality. The laws that the legislature enacts in pursuing its ends must be proportional. What other definition of the non-arbitrary way could the court have devised? Once there is significant but not total empowerment to achieve an end, and to use means to achieve the end, the only way to curtail and control the empowerment is to require the means to be proportional. Let me give you a few examples. The German Constitution protects individuals' freedom to choose and to practice a profession. At the same time, it empowers the legislature to limit these freedom. To safeguard patients' health, the legislature instituted all kinds of controls on pharmaceutical sales, among them a limitation on the number of pharmacies that can be opened in each district. This was invalidated by the Federal Constitutional Court as an unnecessary intrusion into professional freedom that was out of proportion. The legislature could, and therefore should, have achieved its goals by instituting regulations on the storing and sales of pharmaceuticals. The German Constitution also protects freedom of assembly and at the same time empowers the legislature to limit it. The statutory requirement to seek police permission for a public demonstration goes too far and is out of proportion. Notifying the police of the public demonstration is enough to allow the police to make sure that the public demonstration doesn't clash with general traffic. The free use of property, while constitutionally protected, can also be limited by statute, among others by landmark statutes. A landmark regulation that requires an owner to keep up his house even though it has become unusable to him is out of proportion and unconstitutional. If the state wants to landmark the house, it has to expropriate and compensate the owner. In comparative constitutional law, the principle of proportionality is often traced back to German roots. Indeed, in the second half of the 20th century, it was after the German Federal Constitutional Court used the principle already that constitutional courts from most European countries, as well as Israel, Canada, and South Africa, India, made the principle of proportionality the cornerstone of their rights and freedoms jurisprudence. But there's nothing inherently German about the roots of the principle of proportionality, nor is the introduction of the principle into other constitutional contexts a transfer of a German principle. The principle is a response to a universal legal problem. Once it is understood that an authority's reach is extensive, but also limited, without specifying the limits, the principle of proportionality serves as an instrument for reconciling both the extensive reach with the unspecified limits. Therefore, the universal legal problem and the principle of proportionality as a response to that problem are not restricted to conflicts of state versus citizen and citizen versus citizen. When state agencies have conflicting powers, not clearly defined in their reach and limits, and the fiat of a higher authority cannot resolve the conflict, then a court must resolve the conflict, and the principle of proportionality can again come into play. The US Supreme Court relied on the principle of proportionality, perhaps for the first time in its jurisprudence under the Dormant Commerce Clause on the relation between the federal government and the states that the clause establishes. But the principle comes into play primarily in conflicts over fundamental rights and freedoms. Indeed, fundamental rights and freedoms and the legislature's power to limit and intrude on them constitute the field of law in which the principle is most meaningfully employed. Here, courts find themselves with the two premises and not much more. The first, that rights and freedoms are protected against limitations and intrusions. The second, that these rights and freedoms can be limited and intruded upon. Here, the answer must be that the limitations and intrusions must not be arbitrary, but proportional. But rights can also be granted in a different way. The Bill of Rights of the American Constitution protects fewer rights than other constitutions, but protects the most prominent among them categorically. The free exercise of religion must not be prohibited. Freedom of speech, freedom of the press, the right to assemble peaceably must not be abridged. The legislature is not empowered to limit these rights or to intrude upon them. This doesn't mean that the rights can conflict with goals that the state pursues or with rights of other citizens. But without a caveat for legislative limitations and intrusions, demarcations and categorizations help resolve the conflict. The jurisprudence draws lines. The exercise of religion ends where a religion-neutral law, as opposed to a religion-specific law, states its commands or prohibitions. Speech ends when it turns into a fight or commercial action, or as obscenity or defamation lacks the value of speech. It must also end where restrictions are not content-specific, but content-neutral, and refer only to the time, place, and manner of what is said. But all of this doesn't mean that proportionality analysis doesn't come into play in the US. Whenever American courts review limitations and intrusions with strict scrutiny, or a middle tier of scrutiny, or with a requirement of mere rationality, theirs is a means-end analysis that is a more or less thorough proportionality analysis. The often mentioned, praised, or criticized American exceptionalism exists. What it means in our context is that the word proportionality appears only rarely, that the means-end analysis is somewhat haphazard, and that balancing and means-end analysis come systematically later. The first approach is to fine-tune the realm of the right, to specify its inner limitations before allowing for outer limitations by the legislature. Justice Breyer, who advocates proportionality analysis for American constitutional law, is right. Proportionality analysis would not be something alien to American constitutional jurisprudence and scholarship. It would sharpen the American methods of balancing, scrutinizing, and rationalizing. But I understand that American courts and legal practitioners, as courts and legal practitioners everywhere, are not too interested in seeing their methods of legal reasoning sharpened and thereby their discretion restricted. With the exception of the American Constitution, most modern constitutions protect not just a few rights, but a plethora of rights and freedom, with the effect that all behavior, all action, all expression is protected, but the state can limit and intrude upon these protections as long as it does so proportionally. Sometimes these constitutions were the response to a previous totalitarian or dictatorial regime. Lack of freedom in all areas of life leads to an emphasis on the protection of freedom in all areas of life as well. But even without the experience of totalitarianism or dictatorship, in a world ever more crowded and ever narrower, freedom in all areas of life is ever more valuable. With the far-reaching constitutional protection of rights and freedoms in the last decades of the last century, the principle of proportionality spread around the world. In European countries lacking constitutionally protected rights and freedoms or constitutional review, implementation of the European Convention of Human Rights into the national legal system leads also to the implementation of the principle of proportionality into the national jurisprudence. The European Court of Justice, the European Court of Human Rights, and the panels and the appellate body of the World Trade Organization all operate under the principle of proportionality. It may sound as if I mean to say that proportionality works as the solution for all conflicts between the legislature and the citizenry everywhere, and potentially even here in the United States. But it is also the problem, or to be more precise, it is a structure within which all kinds of problems unfold. The first problem is the problem of insufficient or ambiguous information. It is sometimes simply impossible to determine whether a means works and whether it is necessary. The fitness and the necessity of a means is an empirical problem, and often science, scholarship, and experience can help in solving it. But often enough, all one has are assumptions, contradictory experiences, and as many expert opinions as there are interests involved. Climate change is an example. Beyond a basic agreement that climate change is dangerous and has to be countered, information about the extent of the dangers and the effectiveness of the countermeasures is ambiguous and insufficient. The second big problem is that while, at least ideally, it is objectively possible to determine whether a means works and is necessary, the balancing of rights, interests, and values entailed in the analysis of appropriateness is unavoidably subjective. There is no objective standard for measuring and weighing free speech versus privacy, freedom versus safety, privacy versus public health, or the protection of an endangered species versus the creation of badly needed jobs. There are several ways to deal with these two problems. To solve the problem of insufficient or ambiguous information, one can establish a burden of proof rule, under which it is either the legislature or the affected citizen who has to prove that the means works or doesn't work, is necessary or is not necessary. Let's assume that to protect the climate, the legislature enacts a statute that requires car makers to use very sophisticated and expensive exhaust filters. And let's further assume that the effect of the filters is dubious. If the legislature is entitled to limit the citizens' freedom only if it can prove that the statute helps to pursue the legitimate end, in this case that the filter actually helps to protect the climate, then the statute is unconstitutional. If, on the other hand, the affected citizens have to prove that the statute does not help, then the legislature enjoys the benefit of the doubt and the statute is constitutional. No country, or to be more precise, no country's constitutional jurisprudence that I'm aware of follows either of these two burden of proof rules. They all find flexible solutions in between. They make the burden of proof shift depending on what is at stake. If the citizen's freedom that is to be limited is regarded as crucial for the citizen's autonomy, and if the end that the legislature pursues is regarded to be of minor importance for the common good, then some constitutional courts require that the legislature demonstrates the effectiveness and necessity of the statute beyond reasonable doubt. If, on the other hand, the end that the legislature pursues is regarded to be important, and if the freedom that is to be limited is regarded to be of minor relevance, then the courts are more generous vis-à-vis the legislature and allow it to act even if many questions about the effectiveness and necessity of the statute remain unanswered. Of course, there are many ways in which the burden of proof can shift or even be shared by the court itself. There are many degrees of scrutiny, many different notions of what is reasonable and what is unreasonable doubt, many different ideas about what is crucial or at least relevant for the citizen autonomy and of what is important for the common good. So it comes as no surprise that different traditions exist regarding how to distribute the burden of proof between the legislature and the citizens. Different traditions also exist regarding the second problem mentioned, the problem of the unavoidable subjectivity of balancing, the other element of proportionality. One position taken by constitutional scholars around the world is that there is no reason why justices should put their own subjectivity before the subjectivity of the legislature. When decisions are about how to pursue the common good are subjective, then they are political. They need democratic legitimization, and the legislature is democratically legitimized to make them. Only when decisions can be made on objective grounds are experts legitimized to make them. The contrary position, taken most often by judges, is that they, the legal experts on the constitutional or Supreme Courts, because they are appointed by the president or parliament, enjoy at least an indirect democratic legitimacy, and furthermore have the wisdom and time to balance more calmly and carefully the crucial conflicts of a society than the legislature, which acts in the turbulence and heat of political battle. And again, there are many positions in between. Most courts claim the right to control the balancing of the legislature and to replace it by their own balancing, and at the same time emphasize their respect for the results of the democratic political process. This means that they interfere not always, but only on those occasions when they feel a specific urge to do so. Naturally, some courts feel this urge on more occasions than others. One factor determining both how the burden of proof is distributed between the legislature and the citizens, and how activist the courts are when balancing becomes the issue, is the democratic and revolutionary tradition. In France, with its double tradition of a powerful state and a powerful belief in democracy that, since the French Revolution, brought forth almost as many revolutions and constitutions as there were generations, the people trust the political process and accept only a rather weak judicial control of the legislature. In Germany, where in the 18th and 19th centuries the bourgeoisie was too weak to make a revolution and instead invented administrative courts for the protection of citizens' freedom and property, courts and the law enjoy more trust than the legislature and politics. Germany is also among those countries where the democratic political process led to fascism or communism. These countries share a particular hope that a wise and strong constitutional or Supreme Court will tame whatever dangerous tendencies the political and legislative process may have. Another important factor for the distribution of the burden of proof and also for the assignment of the task of balancing is the homogeneity or non-homogeneity of the people. The more ethnic and religious conflict there are, the more it makes sense to shift some of the burden of integration from politics to law and from the legislature to the Constitutional or Supreme Court. South Africa and India are accordingly countries with activist courts. It also doesn't come as a surprise that in Israel, where legitimacy as a Jewish state and legitimacy as a democratic state are not in full harmony, the court tries to establish its own legitimacy beyond and independent of politics. Taking into account all these different shapes and showing all these different facets, does the principle of proportionality still have the distinctive features that allow us to call it a principle? I don't hesitate to say yes. The principle of proportionality is not a simple principle, easily applied and easily yielding answers. It is a complex principle, allowing for interpretations and modifications. But it structures our reasoning and guides us on our difficult path to find answers. The principle of proportionality has had a fantastic career, from a principle of moral philosophy to a legal principle, from a principle of administrative law to a principle of constitutional law. It has been named the ultimate rule of law. And even though there is no such thing as an ultimate rule of law, the principle of proportionality is definitely a rule at which all courts ultimately arrive. Even the US Supreme Court, shy about using the term, when it engages in means and analysis, it follows the rule in substance again and again. Application of the principle has had and will have a standardizing effect on different constitutional cultures. Constitutional cultures with a doctrinal tradition will progressively be transformed in the direction of a culture of case law. The often praised asset of proportionality analysis is its flexibility. From case to case, facts may be assessed differently and rights and interests weighed and balanced differently. The case-specific configuration of facts, interests, and rights becomes more important and more significant than the doctrine that surrounds the case. Judges become more interested in finding the proportional solution for the case than in a decision that fits into established doctrine or helps to modify or to refine it. On the other hand, the principle of proportionality has a structuring quality and potency that introduces a doctrinal element into constitutional cultures with a case law tradition. Another way of viewing this is that the principle of proportionality doesn't have a standardizing effect on different constitutional cultures, but rather that it is a standard that constitutional cultures share and that they become more and more aware of over time. It is part of a deep structure of constitutional grammar that forms the basis of all different constitutional languages and cultures. It comes to the surface sooner or later, everywhere and even here. I thank you for your attention.
Thank you very much.
Professor Doctor, thank you very much for those remarks. I want to first acknowledge, as Jane Austen might have said, that it's a fact universally acknowledged that nobody comes to events like this to hear the respondent. They come to hear the Professor Doctor, and so I'll keep my remarks proportionally brief. So my expertise, such as it is in American constitutional law and particularly in American free speech law. And I want to say a few things about those areas of American law just to underscore what I hope will be a major takeaway, as our friends in the business school like to say, for all of you. And that's that despite the title of this event, that is Proportionality in Constitutional Law, Why Everywhere But Here, in fact, it is everywhere and here. That is, as Professor Schlink said, there is there's a tendency not to use the word in American constitutional analysis, the word proportionality, but it's everywhere just the same. We do not have, as many constitutional regimes do, individual rights provisions that are explicitly qualified or defined with reference to proportionality or the relationship with a certain kind of state interest. So think of some other constitutional regimes that will say, you know, provision 1, the freedom of speech is protected, but there'll often be another provision in that constitution which says explicitly the foregoing rights may be limited in insofar as they're necessary for the preservation of order or the achievement of a just society or something like that. Our Constitution doesn't have such an explicit recognition of the fact, but it's a fact nonetheless that the process and the project of protecting individual rights is one that requires this balancing, this trading off, this assessing of the proportionality of certain legislative measures with reference to the ends that those measures are trying to achieve. Now, that said, sometimes in our Constitution you do see sort of words used that hint at or perhaps invite kind of subtly decision makers to engage in proportionality analysis, very much like that Professor Schlink just described. So our Fourth Amendment puts a prohibition on not all searches and seizures, but unreasonable searches and seizures. And when one drills down into the jurisprudence of the Fourth Amendment, one sees that in fact what's going on in that body of law is that everywhere courts and other decision makers are asking about the purpose of the search in question, the degree to which that search is intrusive, the particular context in which the search is taking place, the costs and benefits of allowing the search, the deterrent measure, that is the deterrent that's achieved by excluding evidence, and so on and so on. Another example, I think, of such an explicit invitation to proportionality analysis might be in Article 1 of our Constitution, when it's acknowledged that sometimes the ancient right of habeas corpus can be suspended. It says in the text quite explicitly that that may happen when the public safety may require it. And insofar as we have any jurisprudence about that clause, it tends to look, I think, a lot like the analysis that Professor Doctor has described. Now let's look at the First Amendment in particular. The First Amendment, as was noted, is set out in fairly categorical, almost absolute terms. Justice Hugo Black was famous for insisting that, in fact, it was absolute, but he wasn't able to actually operationalize an absolute First Amendment, so he ended up having to make compromises in terms of how he defined the scope of that right. So the First Amendment says, for example, Congress shall make no law abridging the freedom of speech. Shall make no law. Now that might seem on its face to rule out proportionality analysis of the kind that's been described, but in fact, and as we heard, it doesn't. It's everywhere. Something like proportionality analysis or balancing of costs and benefits takes place at various places in the process of American judicial decision making. So for example, when we're trying to decide whether the freedom of speech is even engaged by a legislative measure. One of the things we do is ask, well, does this law burden some practice that we recognize as freedom of speech? And there we kind of cheat, right? If we have it in our head that this is an instance where the government should be permitted to act, we often just simply declare, or our courts do, that what's being regulated isn't actually the freedom of speech. It's something else. It's obscenity, it's incitement, it's defamation, and so on. So even in the process of identifying what it is the freedom of speech covers, we are implicitly, if not explicitly, engaging in a balance of individual interests versus state and public needs. And then once we decide that the freedom of speech is even actualized, that a particular measure, say a law regulating indecent speech on the internet, once we decide that that law actually does burden what we acknowledge to be the freedom of speech, we then turn to a method of means-ends review that I think looks almost precisely like what was described. Right? Courts ask, in some order or another, does this measure serve a, quote, compelling state interest? And sometimes they'll substitute another adjective. If so, does this measure actually advance that interest? Right? Does it sort of move the ball in that direction? If so, does it do so in a relatively cost-free way? That is, are the burdens on speech as little as they can be? Is this the least restrictive means that's available to the legislature? Are there other means available that the legislature could have chosen? So we ask, for example, whether the rule in question is over-inclusive. Does it cover more speech than it needs to? Or is it suspiciously under-inclusive? That is, does it seem to be singling out some speech for regulation, but leaving other speech that ought to be treated the same, leaving that unregulated, which might suggest something suspect about the regulator's motives? All that happens usually without using the word proportionality, and this is what Justice Breyer kind of objects to because he wants to speak, I think, a language that looks more like what our colleagues in other regimes use, but I think at the end of the day, the result is pretty much the same. So what's exceptional about American constitutional law and rights-based law is not, in my view, that we're allergic to proportionality review. It's that for some, I think we are more leery of the potential dangers that can accompany it. So when someone like, for example, Justice Scalia will express concerns about judicial balancing in response, say, to someone like Justice Breyer, it's not that he imagines that proportionality analysis is escapable. He knows it's not. It's that I think he's attuned, and we can argue about whether we think he's too attuned or not, but attuned to the anti-democratic dangers of judicial review. And so one thing that I think is worth underscoring is a theme that I heard near the end of Professor Doctor's remarks, which is that there is unavoidably the danger of subjectivity when proportionality analysis is being conducted in law. And so in the American context, I think we've seen, and this might distinguish us, I don't know enough about comparative constitutional law, unlike my colleague, to say, but I think in the American constitutional tradition, we have been particularly sensitive to this worry that judicial review is an illegitimate substitution of one decision maker's assessment of proportionality for that of another. The question, in other words, isn't should proportionality review happen? The question is who decides? Who should conduct that proportionality review, right? Presumably, Justice Scalia might say, a proportionality review or something like it has been conducted by the decision maker whose actions are being evaluated by a court. And what's the justification for letting a court second guess or do over or supervise the proportionality analysis that the other decision makers engaged in? Now, Jeremy Waldron, who's a very distinguished scholar, I'm sure many of you are familiar with his work, he has suggested that in a constitutional democracy like ours, that is, like the one we have here in the United States, which is basically well-functioning, that in fact, the case for judicial review, judicial second-guessing of the cost-benefit determinations and trade-offs and balancing done by legislatures is hard to justify. Note, that's not a case against proportionality analysis. It's a case against, or at least a question raised regarding aggressive judicial review of the kind that our court enjoys engaging in. Now, why does our court enjoy engaging in it? Professor Schlink noted at the end that a particular regime's attitude toward proportionality might depend in part on its traditions, its experiences, whether with revolutions or what have you. In America, to make a very long story unpardonably short, it seems to me we can say that for most of our constitutional experience, we were kind of skeptical of judicial review, of judicial second-guessing of policy determinations. And we could point to a case like Dred Scott, where Supreme Court judicial review and invalidation of a legislative measure strikes us, indeed it struck President Lincoln at the time, as monstrously unjust. And then so we see a phase for the years, say, between our Civil War and the landmark case of Brown versus Board, where our court, with a few exceptions obviously, pulls back from aggressive judicial review in many, not all, areas. But where we are today, I think, is unavoidably and inescapably a product of the story that we tell about what the Supreme Court did in the desegregation cases. Right? That's an instance where, again, according to this story, our court intervenes, second guesses the policy judgments that are being made by some legislatures, and we all agree, thereby promotes justice. That move and the sort of acceptance of it has, I think, empowered our court to be more confident in its ability to engage in proportionality analysis than it might have at other times. And perhaps we might think to make it more confident than it really should be. Thanks.
Good afternoon. Apart from being a very distinguished novelist, you should know that Professor Schlink is one of Germany's most notable and reflective constitutional scholars. And I'm really delighted to be able to share this platform with him this afternoon. I've prepared a set of very brief remarks based on the larger formal paper that Professor Schlink submitted some weeks ago. And in the course of my remarks, I'm going to be striking notes a little bit different from the notes that my colleague Rick took note of. We have some differences, but I suspect that they will be differences more of style, shall I say, or emphasis rather than differences of substance. In any case, Professor Schlink has given us a splendid overview of the uses and the misuses, by the way, of proportionality analysis in constitutional law. He concedes the universal appeal of proportionality in constitutional decision-making, and he acknowledges its muscularity in the protection of fundamental rights. But he is also critical of some of its applications. At least that's the way I read his paper. In fact, I don't think I'm off the mark in suggesting that he is probably one of Germany's strongest critics of some aspects of proportionality analysis. Although I think that he would admit that his view is a minority one among constitutional scholars in Germany. But among American constitutional scholars, I'm sure that his views would receive a warmer reception, particularly Dworkinian judges and scholars who prefer categorical analysis or approaches overbalancing in fundamental rights cases. Professor Schlink's main criticism boils down to this: the cost-benefit analysis that is an inevitable part of proportionality review in the narrow sense is invariably political. Political because the courts do little more than to substitute their own fallible subjective judgments for those of the legislature, leading to an unacceptable degree of judicial activism. Equally bad, in his view, is that balancing provides no firm basis for predicting the next case to come along. In his wide-ranging discussion of proportionality, Professor Schlink refers to its use mainly in Germany and the United States. And what I would like to do in the few minutes remaining given my interest in comparative constitutional law, is to point out where the German and the American approaches to proportionality differ, and then to suggest why, in my view, the German approach may be preferable to the American. As Professor Schlink notes, proportionality reasoning usually begins with a court's insistence that a statutory limit on the exercise of a basic right be justified by a lawful policy objective. Here already, Germany differs from the United States. In Germany, any valid public policy will do so long as it is not prohibited by the basic law being Germany's constitution. Germany's federal constitutional court rarely strikes down a law at this initial stage of inquiry. In the United States, by contrast, the Supreme Court sets the bar much higher and strikes many laws at this stage, especially if the public interest is found not to be compelling or important enough to justify limiting the right, even though the end may be legitimate. Now, once the legitimacy of the policy objective is established, the German court then embarks upon its analysis of proportionality. And this is usually a three-step process of examining the relationship between ends and means, as Professor Schlink noted. In steps 1 and 2, the German court simply asks, respectively, whether the means furthers the pursued aim, and then whether the law minimally impairs the right. Now, interestingly, the German court rarely strikes down laws in these initial steps, largely out of deference to the legislature's fact-finding capacity. By contrast, our Supreme Court strikes many laws at this stage for not meeting the necessity or minimal impairment demand. Anyway, up to this point, I want to suggest the German court has not really engaged in balancing, although it is, I guess, a form of proportionality, but rather its judgments, it seems to me, have been legal, not political. In Germany, the actual balancing process takes place in step 3, where the Constitutional Court attaches weights to the individual right and the public interest which are in conflict. And here the court may well find that the means are disproportionate to the end, even if the means are necessary to achieve the end. Now, this gets complicated because in Germany, the court not only weighs competing interests, but also, and often, as Professor Schlink has noted, it seeks to reconcile competing rights conceived as values or principles. One of these values is the principle of human dignity, and all Americans should be reminded that this is the master value of the German Constitution, much as liberty might be suggested as the master value of the U.S. Constitution. And this value of human dignity is one that in Germany informs the scope and the meaning of all constitutional rights. So no one individual guaranteed right can be evaluated in Germany without a consideration of what it implies in terms of human dignity. Bear in mind that you can reject an interest or a discrete rule, but not a principle. And if competing principles are involved, they must not only be reconciled, but optimized, as the Germans like to say, and optimized in a way that conforms to the basic law's master or overarching value of human dignity. In short, this is not a zero-sum game, as it often is in the American situation, where one principle trumps another. Principles cannot trump each other as principles. This kind of balancing is not in the American Supreme Court's toolkit, and that's what I want to emphasize here, and I think that's what Professor Schlink was suggesting. Except perhaps in the areas of criminal punishment and dormant Commerce Clause analysis. Our court usually starts out by adopting a standard of review that may range from strict scrutiny to mere rationality, depending, of course, on the right or the classification under inquiry. And at the highest ends of scrutiny, the statute or practice under attack is presumed to be unconstitutional unless the state can meet the specified burden of proof. This is the kind of judicial activism that I think Professor Schlink opposes. So far as I know, and both Rick and Professor Schlink have mentioned this, Justice Breyer is one member of the court, I think really the only member of the court, the Supreme Court, who favors bringing step 3 of proportionality into American constitutional analysis. Consider, for example, his recent opinion in United States versus Playboy. That's a recent opinion. I think that goes back to 2000, doesn't it? Yeah. By a 5-4 vote, the Supreme Court struck down a section of a congressional statute whose objective was to limit children's access to sexually explicit material on cable television. Breyer dissented, interestingly enough. In advocating a balancing approach, he argued that instead of applying First Amendment rules mechanically or categorically, a judge should decide, these are his words, whether in the light of the benefits and potential alternatives, the statute works speech-related harms, here of course to adult speech, out of proportion to the benefits that the statute seeks to provide, here of course child protection. By the way, he seemed also to be calling for proportionality review in Snyder versus Phelps, the Marine funeral case in which just a couple of weeks ago, the Supreme Court overturned a judgment against a religious group for causing the father of a dead Marine severe emotional distress by the signs the group displayed near the site of his son's burial. Although in this particular case, Breyer was on the side of striking down the court judgment. Now, of course, it's worth noting that Justice Breyer likes to cite foreign constitutional law as a possible guide to the interpretation of the U.S. Constitution, much to the chagrin of Justice Scalia and his conservative colleagues. Matter of fact, some years ago, in a Commerce Clause case, he even condescended to cite my work on Germany's federal constitutional court. Let me close with what is probably the most prominent example of balancing analysis in German constitutional law, namely the famous abortion case of 1975, which many commentators, myself included, have compared with Roe v. Wade. In that case, the German court was asked to rule on the constitutionality of a liberal abortion statute enacted by the national parliament. In deciding the case, the court felt it necessary to reconcile conflicting principles, not interests as such. The conflicting principles involved were the right to life and the right of the pregnant woman to the free development of her personality. Both rights, by the way, are anchored in the basic law. The question before the court was how to optimize these conflicting principles in the light of the higher principle of the value of human dignity. The court ruled, to make a long and complicated story short, that unborn life is life within the meaning of the Constitution, that abortion is an act of killing, and hence the statute permitting abortion virtually on demand in the first trimester of pregnancy was declared to be unconstitutional, turning, of course, Roe v. Wade exactly on its head. Yet the court did not dismiss the importance of the woman's right to liberty or autonomy under the Basic Law's Personality Clause. The court went on to list the conditions of hardship, including certain degrees of social hardship that would in fact require the state to permit an abortion to go forward. In my view, the merit of the German case is that both values were honored in this instance. Roe v. Wade, by contrast, absolutized the right to privacy. The result seemed as simplistic as it was dogmatic. Everything for the woman and nothing for unborn life. I would only note in conclusion that the case is a bit more complicated than this, and that Professor Schlink, by the way, is one of Germany's strongest critics of the abortion decision. I would only note that the differences in the approaches of the two courts are to some extent related to the differences of our written constitutions, the constitutions of the two countries. And I'm going to have to leave it at that. Thank you very much for your attention.
I'd like to invite Professor Schlink to come up and respond to your questions. It's part of the Nanovic Institute's tradition to take a question from a student first.
I can call someone if you'd like.
Maybe that'll lead to a question.
I'm not a law student, but I have a question about the free will of the grandmother or the mother that was waiting at the train station. This is still bothering me. And maybe it's a hypothetical piece, but couldn't she have gone in the train station and saved herself from a crossbite?
Well, it's a valley, and there's just this little hut where you stand and wait for the next bus, or wait to be picked up because you got off the bus and your relatives pick you up. So that was all she had, and standing there for 2 hours, she got frostbite.
All right, I'll buy that, but not very well planned considering how cold it is.
Well, I mean, she relied on her son picking her up, and her son was willing to pick her up, and he would have picked her up if his car hadn't been taken away.
Yes,
I count myself as a student also, although I'm perhaps, here we say a first-year student is a 1L. I think I'm about a 43L or something like that. I'd have to go back and count. This is a very difficult topic, not only for law students, but I think for people who aspire to some scholarship in the law, because in order to really evaluate it, it requires an extent of knowledge about more than one legal system that very few people have. Don Kommers is one of the leading experts in our country. Rick was struggling with the fact that he's so familiar with American law and not so familiar with German law. And as I teach international human rights law, and so as I listened to this debate, I was thinking of the methodology used by the European Court of Human Rights to deal with similar issues, where they look at, first of all, is the end legitimate? Secondly, is it declared by law? And then thirdly, is the balancing test, where they ask, is the means chosen necessary in a democratic society to meet a pressing social need? And so I was trying to compare that jurisprudence with which I'm familiar to the German jurisprudence with which I'm not familiar. And so here's my question, in the light of the fact that there are very few people in the world who know enough, I think, to answer this question. It sounds to me as if it may well be that the method used to get to the end doesn't affect the end that much. And that whether you use a German-style proportionality test or the various approaches that the American Supreme Court uses, what really matters in the end are the relative weights placed on the goal to be achieved by the restriction or the right that is restricted by the restriction. And that those in turn flow from the cultural values of a society and from the different perceptions of those cultural values by judges who come from different philosophical or ideological schools. So to put it in perhaps other terms, suppose someone has an old clunker of a car that will not go above 32 miles per hour no matter what happens, because fourth gear doesn't work anymore. And someone else has a very healthy horse that can run exactly 32 miles an hour. And they're each asked to go a mile down the track. Well, they're using very different methods to get there, but they're going to get to the same point at the same time. do any of you, and starting with you, Professor Dr. Schlink, do any of you think that the method used is likely to be outcome determinative, or is it instead just a different horse or a different car, and the outcome is going to depend on the values that a society and an individual judge or a legislator place on the competing interests?
Well, I would say yes and no. And the yes part is, first of all, I don't think that courts are more or less activist because the methods allow them to be more or less activist. They are more or less activist because they want to be more or less activist. And if they want to be, then they find ways. And so I wouldn't quite agree that the United States Supreme Court is against balancing because that would draw him into an activism that it wants to avoid, at least from a foreign perspective. The US Supreme Court is one of the most activist and politicized courts that we see. So on the one hand, courts find their ways and means to be activist if they want to. On the other hand, methods make a difference. And let me give you two examples. One is from Germany. So proportionality analysis has these four elements. First, you have to identify the end as legitimate, and then fit, and then necessity, least intrusive means, and then balancing proper. And if you look at the jurisprudence of the German Constitutional Court, for many, many years, or even the first decades, the proportionality analysis focused on fitness and necessity. And they really got into the empirical issues of that. And that's where they found the solution. And if it was not necessarily the case was over anyway, and if it was necessary, they were kind of reluctant to get into balancing, because in a way you can say if something is necessary, then it seems to be of some value. So they were reluctant to enter the balancing stage. While more and more over the decades, because these first steps have a disciplining effect that if you are an activist court, feels more like a burden than really helpful, they gradually moved into focusing on balancing. And once you are in balancing proper, you are free to bring your subjectivity into play. So this shift in the focus on what's the significant, the important element of this four-step method made a true difference. Another example, I think, is Great Britain, where they controlled administrative action with a rather loose, reasonable standard. And reasonable also has to do with means and ends, but it's very loose. And under the influence of Strasbourg, and because now the Human Rights Convention is part of English law, they engage in much more thorough controlling analysis of administrative action. So it makes a difference. But if a court wants to balance, it balances when it's about the compelling interest, or it balances when it weighs interests and rights and values. If a court wants to be activist, nothing can really stop it. And I think in a way that Tolstoy says all happy families are alike, only the unhappy families are different, the beginning of Anna Karenina. All happy courts, happily enjoying rich power courts, are alike insofar as they become ever more activist. And a nice example is Austria, where the court was kind of, all the judges were brought up in this Celsenian tradition, be non-activist, But once the Austrian Constitutional Court got more powers, they did what all courts do. They became more activist. And I really thank both my commentators for their thoughtful remarks, and I agree that in the United States, the means and analysis again and again resembles proportionality analysis. And on the other hand, in Germany, proportionality analysis has taken on different forms and shapes. So in a way, we have it all. And the question is, and I didn't understand Justice Breyer as focusing just on this last stage. I thought he was also concerned about a thorough fit and necessity analysis in every case. I think the more we have of that, of these rather objective analytical steps, the better it is to somewhat discipline our courts, who all have embarked on this journey into ever more activism.
Did either of you want to respond quickly?
No. What is interesting about the German court is that when it engages in this methodology, it really thinks it is engaged in objective constitutional decision-making. The reason being, it tries to ascribe a specific weight to the right that may be involved, as well as a specific weight to the public interest. It's almost like mathematics. And then, of course, they're making the decision accordingly. But there, just one very brief comment. There's also a large category of cases that the Federal Constitutional Court decides in fundamental rights areas involving judicial judgments below, where you have a case, for example, involving somebody who is given a libel judgment because he or she thinks that he or she has been maligned in public. So the libel judgment may be upheld. And then what the Constitutional Court has adopted a very interesting technique. The balancing must take place in the lower courts. That's where the balancing takes place. And when the case comes up to the Federal Constitutional Court for decision, what the Federal Constitutional Court does is simply to determine whether the lower court has taken into consideration the significance of the basic right in deciding the case. If not, then the Federal Constitutional Court will reverse the judgment. If the lower court has taken into consideration the scope and the meaning of the basic right involved, the court will uphold the judgment, even if the Constitutional Court does not agree with the way that the equities have been balanced in the first place. I think that's a very interesting approach to it. Is that right, Bernhard?
Yeah, that's right. I
So
think that
the court really does not engage in balancing in those cases.
unless it wants to. And what's also interesting in the abortion case, proportionality normally means don't do more than necessary. In the abortion case, the conservative court invented a principle, don't do less than necessary. And once the court presumes the right to decide between too much and too little, then of course it has full discretion. And this happened in the first abortion case. I wouldn't focus on the weighing and balancing in this first decision that much, but I would focus on this other instrument. They said, well, if there's no punishment for abortion, then the unborn life isn't protected properly. So it's unproportional because it is, so to say, not over-proportional, but under-proportional. And that allowed them to declare it unconstitutional too.
How eager a judge is to get to a certain point, if that makes any
I have to be somewhat attentive to the time here, so what I'd like to do, kind of as an experiment, is see if I could collect some short questions and then challenge our guest to somehow provide a synthesis in his response to them. Now, what I'm counting on here is that the synthetic opportunity will already be present in the question. So I'll start with Vittorio.
You gave me the example of the boy that was eating apples. As far as I remember, in the German criminal law, it is so that every step which is necessary and act is justified in the case of self-defense. This means that in German law, in difference, for example, from Italian criminal law, you are allowed to shoot on a thief who flies away, who flees with some of your property, and it is only the law of judges that has somehow mitigated the very sharp determination of the law. And my other question is, in the criminal law, in Article 34 on the rechtfertigen Notstand, we have some idea of proportionality that even outside of self-defense situations, I'm allowed to violate a legal good, for example, the property of another person, if this is necessary in order to save a much higher good. And of course, this presupposes that there's an objective hierarchy of goods, even if the Strafgesetzbuch does not lay these goods out. How do you think that this principle is connected to the weighing activity of administrative and constitutional lawyers?
I just want to ask you, put out a hypothesis that part of the explanation for the, and see how people respond, part of the explanation for the American exceptionalism of not being happy with even talking about proportionalism for the most part, even though one engages in it, is a consequence of the fact that our Bill of Rights was essentially directed only at the Congress and not at the states. And it only becomes a general principle of our jurisprudence after the Civil War, when the court, its own motion, essentially extends the Bill of Rights to the states, so that you can stay flat out, Congress shall make no law respecting whatever, but that does nothing with respect to other legislatures. And that's part of our history. So the flat-footedness, the categoricalness, does that make any sense? I'm not a constitutional historian, but does that make any sense to those of you who are? The categoricalness fits that.
We'll take one more, well, two more quick questions.
Thank you, Professor Schlink. I'm Bernd Göring. I'm from the program of liberal studies here. I'm not trained in law. But my question is, what should the judicial system do when there's perhaps obstacles emerging to have a chance to engage in exercising proportionality, such as, say, in this country, use or ever more frequent use of the state secrets doctrine that would lead to maybe throwing out entire cases before there's greater insight even into weighing different interests or rights that might be at issue, because it's like a rule that trumps everything and doesn't let certain things go forward anymore. And so certain, even basic exercise of proportionality wouldn't come into play at all, perhaps.
Finally, Catherine.
My question picks up on Professor Schlink's conclusion, in which you stated that proportionality began as a moral principle and then became a constitutional doctrine. Proportionality sounds a lot to me like Aristotle's definition of justice and then the key in ethics. So I'm wondering what difference there is between the moral principle or the decision of what's just and the court's decision, which I think in the German case, as in the American case, is supposed to be not a decision of what's just, but a decision of what's legal.
Thank you.
Well, thank you for these wonderful questions. When I went to law school, the lame guy, was still allowed to shoot the kid down. Now he isn't anymore. No, but they definitely read the law so that he isn't allowed to do it anymore. And you say how to sacrifice something for a higher good, doesn't this involve balancing? And how can I reconcile this with my skeptical view on balancing? I think we have, in a way, balancing and balancing. I don't think that we have a very hard time to balance a life against 7 or even 12 or 24 apples. And that's not a political decision. It's a decision that the legislature has allowed the judge to make. But those decisions that the legislature makes itself, that it doesn't delegate down to an administrative agency. Of course, administrative agencies also balance constantly, and they are empowered to balance. And who empowers the court to balance instead of the balancing of the legislature? That, I think, is the problem. Once we have a judge or an administrative agency that is more or less explicitly, through the statute, empowered to balance, I think we don't have a problem. That's not a political decision. And those decisions are oft really as simple as comparing apples with a life. You made your historical observation, and you say that the categorical character of these rights has to do with how they came into existence. That makes sense to me. And again, I think basically we agree. Even though they are categorically granted, you come to a point where you have to come up with some means and analysis. But before you get there, I think in the American tradition, the attempt to fine-tune and draw lines and specify the limits of the right play a bigger role than they play in the other culture, where you come in with means and analysis, with proportionality analysis right away. Your remark or your question, where proportionality analysis is the cornerstone of rights and freedoms jurisprudence, it's also the point where all state safety and security endeavors are being measured. So if the state says for our security we have to keep this secret, it has to make plausible why this should be secret, and depending on how strict we formulate the burden of proof, he has to show that it's necessary. And that often enough isn't easy. And we have a number of decisions where the police or the Secret Service wanted something, and then when having to argue that it is necessary, it failed. Justice and proportionality, Aristotle and our Supreme and Constitutional Courts. The article that I had to write for this handbook begins with Aristotle because, yes, there it begins. And I think Aristotle, at least at first glance, just looks at two things that have to be in proportion. And only when you read him carefully, you realize that there's always a third thing involved, something to which you have to put these two things into relation. So he doesn't talk about ends, but often puts means into the relation. And then when you read him carefully, you realize, yeah, he's also dealing means and ends. But often it looks like it's just two things that have to be in proportion. So that's where it starts, but it's not. He doesn't develop a full-fledged proportionality analysis.
Thank you very much, Professor Schlink. We have here a small gesture of our gratitude. Thanks for visiting us. We actually have two gestures. First of all,
Thank you.
for all of the different folders and Lord knows what we've been presenting you with. And also a book we like very much of Photos of Notre Dame. So I want to thank you for this most stimulating discussion and thank all of you for joining us.